afternoon, everyone. We'll bring the committee back to order.
This is the Ontario Parliament Television Network.
Okay, I understand Mr. McKeever of the Freedom Party of Ontario is here. Would you mind making your presentation now? Thank you.
I have brought...
you have 20 minutes, Mr.
Yes, and I brought 20 copies, or actually 30 copies of my presentation, as per the request of the clerk's office. I should just add that I spoke with Ms. Selleck a few days ago, and she did intend to be here. She intends to be taking the train in.
Well, I called her name. It's a little early for her, but the only reason I called her name is because the next presenter's not here, so
okay.
We'll hear from you and then go back to see if he comes. Okay.
My name's Paul McKeever. I'm a lawyer in practice in both Toronto and Oshawa, employment law. I'm here as a member of the Freedom Party Executive to make submissions on behalf of the party. The Freedom Party of Ontario is a political party registered pursuant to the Election Act. Freedom Party's statement of principle is that every individual in the peaceful pursuit of personal fulfillment has an absolute right to his or her own life, liberty, and property. Freedom Party is in favor of laws that discourage the initiation of coercive physical force by any person against any other person, of the use of coercive physical force only in response to, and as a consequence of, the coercive use of physical force. Examples include laws that punish a person for stealing a person's property or causing physical injury to a person without their consent. Freedom Party strongly objects to Bill 155 in its current form. Some of Freedom Party's objections are philosophical and some are legal, and they're set out in the following pages. First, the philosophical objection. In considering the philosophical objections listed below, it's important to keep in mind that were it made law, Bill 155 would essentially allow a person to be punished without having committed any offense, except the one which, as explained below, is actually implied by Bill 155 itself, the simple possession of property. In short, rather than being a response to the initiation of coercive physical force, Bill 155 would promote and legalize the initiation of coercive physical force. It would promote and legalize the commission of an immoral activity. Pardon me. For hundreds of years, our legal system has recognized that every person has an unalienable right of life, liberty, and property. Indeed, our criminal laws are designed primarily to protect those rights. Property in this context has not its formal legal meaning, but its informal meaning. Property refers to money and other goods, as opposed to services. Some people, including some Freedom Party members, believe that these rights are God-given. Others believe that they are a result of utilitarian or objectivist philosophies. But one thing is certain. In our society, the protection of the right to one's property is necessary if a person is to both survive and thrive. Indeed, the right of life is meaningless in our society if it does not imply or otherwise include rights of property. As will be discussed below, under the legal objections section, it is our submission that Bill 155, were it made law, would violate the right of persons to their property. Freedom Party disagrees fundamentally with the notion that the moral righteousness or wrongfulness of taking another person's property by the use of coercive physical force depends on who is so abusing physical force. Theft is theft, no matter who may be the thief. It is morally wrong for B to steal from C, whether B is Her Majesty the Queen, one of her ministers, or simply one of the Queen's subjects. Moreover, it is not more defensible to commit a theft indirectly or via an agent than it is to commit a theft oneself. It is never morally defensible for person A to have person B steal person C's money for person A's benefit. that B may be Her Majesty or one of her ministers, acting on the advice of A and C's elected representatives, does not somehow make the theft morally righteous. Freedom Party supports, or submits rather, that it matters not to what purpose Her Majesty or her finance minister would put the property taken under Bill 155. A theft cannot be morally excused or justified by the thief's decision to use his booty for noble causes. Were a mugger to steal from one person in a dark alley but to subsequently give the stolen money to victims of crime or to police so as to prevent muggings, such expenditures could not negate the fact that the mugger's theft was morally wrong. Nor could the mugger's theft be made morally righteous by the fact that she, while mugging a person in a dark alley, held the title of Queen or Finance Minister. And most certainly, the immorality of such theft could not be negated were the mugging to occur in a well-lit courtroom instead of a dark alley. That Bill 155 would allow Her Majesty, through her Minister of Finance, to use the so-called special purpose account only for laudable purposes is no answer to the moral wrongfulness of taking a person's property by force without their consent. History is rife with men of the people who have made their fortunes through crime, but whose crimes have been excused or justified by the public because such men of the people have spent some of their ill-gotten gains in philanthropic ways. It is inexcusable for Her Majesty to join the lowly ranks of such cons and to seek an excuse or justification for the theft via a promise to spend the proceeds of forcefully taken property on such things as victim compensation and crime prevention. That is precisely what Her Majesty will be doing if Bill 155 is passed into law. Moving on to Freedom Party's legal objections, there are certain points within the bill that we think attention should be brought. First, the term unlawful activity includes any offense, whether an offense under federal jurisdiction or under a jurisdiction of any province. The offensive activity or omission in question need not constitute an offense in Ontario at all. The term unlawful activity includes not only acts, but omissions. Thus, as examples, a failure to file one's tax return, to file a party's election finances returns, or to carry on business under a name that has not been duly registered under the Business Names Act is unlawful activity under Bill 155. The term proceeds of unlawful activity includes not only property acquired as a result of unlawful activity, but also property any part of which was acquired as a result of unlawful activity. For example, a bank account of $250,000 or a house purchased with such money is proceeds of unlawful activity if only $1 of that money was acquired as a result of unlawful activity. The term proceeds of unlawful activity includes property acquired indirectly as a result of unlawful activity. Thus, as an example, property acquired via a business that violated Quebec's signage language laws would arguably be proceeds of unlawful activity. As noted above, the unlawful activity need not constitute an offense in Ontario. A court may make an order allowing Her Majesty the Queen to take a person's property even without attempting to prove that the person was at all involved in an offense of any sort, except that implied by the bill itself, as we'll explain in a minute. Bill 155 would allow Her Majesty to take property that has never been involved in any offense at all. For Her Majesty to take the property, it need only be of the type that is likely to be used to engage in forms of unlawful activity that would involve the acquisition of property or the infliction of bodily harm. The most obvious targets, of course, are such things as money, because it is likely to be put to any purpose known to man. Computers, firearms, communications equipment, boat, trucks, well-guarded or remote tracts of land, etc. Now, having looked at those particular sections, these are our legal submissions. Bill 155 imposes not a compensatory remedy, but a fine. This is evidenced most persuasively by the fact that the term proceeds of unlawful activity includes property only a minute part of which was acquired as a result of so-called unlawful activity. Were the aim merely to ensure that no person possessed ill-gotten gains, Bill 155 would not seek to take legitimately obtained property as well. In Canada, fines are imposed only for the commission of an offense. The offense imposed by Bill 155 is an absolute liability offense. The Crown need not prove that the accused knew or intended to possess or own proceeds of unlawful activity or instruments of unlawful activity. The Crown need not prove that the accused had mens rea. The Crown need only prove that the accused possesses or owns the property in question. Bill 155 would not require the Crown to prove its case beyond a reasonable doubt, but merely on a balance of probabilities. In other words, an more likely than not standard. In Canada, the commission of an offence, even for example a moving violation, must always be proven beyond a reasonable doubt. Thus, Bill 155 involves a colorable attempt to impose the more likely than not standard, or the balance of probability standard, to convict persons of an unnamed, undefined, absolute liability offence without proving them guilty beyond a reasonable doubt, and without proving that they had any intention to possess or own proceeds or instruments of unlawful activity. Freedom Party submits that this is not in accord with fundamental justice under Section 7 and related sections of the Charter. It is noteworthy that pursuant to Section 462.37 of the Criminal Code, which is a federal statute, a forfeiture order of the sort sought by Her Majesty under Bill 155 can be obtained only when the person from whom it is taken has been convicted of an enterprise crime. Under the federal regime, it is expressly noted that a forfeiture order is part of one's sentence for having committed an enterprise crime. Moreover, if the enterprise crime is not proven on a balance of probabilities to have been done in relation to the property in question, the property can be taken by Her Majesty only if the Crown proves beyond a reasonable doubt that the property was nonetheless proceeds of crime. Clearly, Bill 155 is a shameless and colorable attempt to circumvent the hurdles associated with the federal proceeds of crime regime. Indeed, a forfeiture order under Section 3.1 of Bill 155 could be made under circumstances that would not allow Her Majesty to take the proceeds of crime pursuant to Section 462.37 of the Criminal Code. Freedom Party fully expects that if the Crown attempts to impose liability on a balance of probabilities, its attempt will not survive scrutiny by the Canadian Charter of Rights and Freedoms, in particular Section 7 of the Charter and the legal rights which serve to elucidate those rights. Because legal proceedings under the bill would be commenced via the commencement of an action, the rules of civil procedure would apply. That being the case, an accused would be required to make full disclosure of all documents relating in any way to the offence and would be required to answer all relevant questions put to him under oath during examinations for discovery. The bill would require an accused to provide evidence against himself, rather than leaving it to the Crown to collect evidence in the same way as it is required for any other offence. Freedom Party submits that this would violate an accused's rights under Section 7 of the Charter. Not only would the Charter be violated by the absence of a requirement that an accused be proven guilty beyond a reasonable doubt, but the Section 7 right to life, liberty, and security of the person could be found to include, as a necessary aspect of the right to life, or of the right to security of the person, the right to property. In connection with the latter point, former Attorney General Flaherty's public statements that the Charter does not protect property rights are, to say the least, premature. The Supreme Court of Canada did not conclude in the leading on-point decision, which is Aaron Toy, that the Charter does not protect property rights. To the contrary, it stated that it would be premature to rule out that security of the person encompasses some economic rights for humans but not for corporations. Moreover, the court had nothing to say about the scope of the right to life. Freedom Party submits that there are strong arguments that the Charter protects a right to property which Bill 155 could not withstand were it made law. As noted above, Bill 155 imposes a penalty for an offence which it chooses not to name. Specifically, the offence in question is the possession of proceeds of an offence or instruments of unlawful activity. Freedom Party submits that such a law is criminal in nature. Indeed, Bill 155 would make Section 462.37 of the Criminal Code redundant. Freedom Party submits that if the Crown attempts to make Bill 155 a law, it will fail on the basis that the criminal law is a matter falling under the exclusive jurisdiction of the Federal Parliament. Furthermore, Canada has a constitution which is, quote, similar in principle to that of the United Kingdom, as can be seen in the Constitution Act 1867 in the preamble, and is governed by the same Crown that has agreed to the terms of the Magna Carta and the Bill of Rights. As evidenced by the Crown's signing of the Magna Carta and decisions made in the Crown's courts since that time, including Ontario's courts since the imposition of the Charter or the coming into force of the Charter, the Crown has given up its power to take a person's property without immediate payment to, or the consent of, the person from whom the property was taken. What I'm saying is that the Ontario courts have recognized that the Magna Carta is still in force and still part of our Constitution, and that the common law still gives us a right to property. If Bill 155 does not impose a fine, then the Crown lacks authority to, in other words, if it's not a punitive or offense-oriented bill, then the Crown lacks authority to act on the advice of the provincial legislature to make Bill 155 law. Her Majesty doesn't have the power anymore to take property without giving compensation, so the legislature can't advise her to pass such a law. Quite apart from constitutional arguments, it should be obvious to anyone that the threshold for granting of a forfeiture under Bill 155 would be so low, the scope of the terms proceeds of unlawful activity and instrument of unlawful activity so wide, and the possible value of forfeited property so high, that government will find it irresistible to seek forfeiture of property connected in no way with an offence. This, of course, is one of the points made to this committee, or that will be made to this committee, I presume, in detail by Ms. Selleck, and we won't expand on those. If there's any time, if there's any questions, I can...
There's about 2 or 3 minutes, if there are any questions. Mr. Tilson?
Yes, you spent some time, at least I shouldn't put words into your mouth, with respect to Section 3, subsection 3, and that is the section that talks about legitimate owners.
Responsible owners. Responsible,
yeah.
Yes.
Your comments about that issue, about seizing property, I think you gave the example of $1 that may be illegal and the rest of it isn't.
Right.
Isn't there a way under this bill, at least I believe there is, to sever that?
Under the bill, the bill actually imposes a new duty on all people who own any sort of property that might be used in any sort of offense, be it a speeding offense or not filing one's, party returns. That if they don't take all reasonable steps necessary to prevent the use of that property in the commission of any offense, then they are not entitled to have that property back.
Well, the subsection 3 says the judge can, where it would clearly not be in the interest of justice, can make an order to protect the legitimate owner's interest in the property. I believe that satisfies your concern. But you're a lawyer, you can tell me whether it does it or not.
Yeah, in Section 2, sorry, in the Part 2 of the Act, responsible owner is defined. I think it's responsible owner, responsible. In any event, it's defined in such a way as to impose a duty on a person. Now, it may be that Part 1 allows a judge in his discretion to award a legitimate owner as
judge can protect that property. That's what that section says in my opinion.
That's what it says, but Part 2 does not give the judge that similar protection. In fact, it only gives the judge authority to return the property to the rightful owner if the rightful owner of the property, be it a rifle or a car or whatever, has taken all reasonable steps to prevent its use in the commission of an offense.
This bill is... Thank you, Madam Chair.
Sorry. Yeah, we really don't have time for any more questions of this speaker. Thank you for coming this afternoon, Mr. McKeever.
Thank you.